talk about delay to your traffic court hearing. There was a very interesting case decided by the BC Provincial Court where a person's traffic ticket had not been resolved, not completed, by more than 20 months after the date the ticket was issued. The general rule in Canada is that if your case takes more than 18 months from start to completion, the charge should be thrown out on the basis of unreasonable delay. But there are some exceptions, and this recent case has a very interesting exception. The first court date was adjourned because the officer had not provided disclosure to the accused. The officer had taken the position that the lawyer for the accused ought to have provided a signed authorization from their client in order to get disclosure. That's not how it works. If a lawyer says, I'm representing somebody, please give me the disclosure, the officer, the Crown, is obligated to accept that and to provide the disclosure. That's the state's obligation. That adjournment did not follow the feet of the defense. The second adjournment, however, was caused by the defense filing an application for a remedy of a judicial stay on the basis of unreasonable delay. But that application was filed before the matter took 18 months. It was not over the time frame. The only reason the matter went over the time frame was because once that application was filed, the traffic court hearing could not proceed, and the matter had to be scheduled in front of a judge for the argument about the constitutional violation. And the argument at the constitutional violation hearing was ultimately rejected on the basis of the fact that it was unreasonable to file an application arguing unreasonable delay in circumstances where the application was meritless, where it was no chance that it was going to succeed, because at the point that the ticket was scheduled to be heard, it was still within that presumptive ceiling of 18 months. You essentially can't create the delay that you then complain of by complaining of the delay that hasn't yet happened. And that's exactly what happened in this case. A lot of people think that they can play smart with traffic tickets by filing applications for delay or by filing adjournment applications in order to try and extend the length of time it takes for their case to be heard. But that does not work, and the court will see through those efforts to try and extend the amount of time by filing applications prior to when they would be applications that would be brought with merit and not fruitless, as the court characterized this one. So if you're worried about delay to your traffic ticket, remember, the magic number is 18 months, and that's 18 months of delay caused by the court or the police officer, not 18 months of delay caused by you. And number two, if it's below 18 months, don't file anything to try to extend the length of time that doesn't have a legitimate and sound basis in law.